This is part 22 and the last part as far as the series of lectures on the Negotiable Instrument Act is concerned, subject to one condition, and that is, if you have not followed any topic or any point which you want to clarify, by all means you can write to me, you can email to me, and then I shall upload one more video for the purpose of dealing with the maybe queries, maybe difficulties, or as per your suggestion. That was what I had done when I had uploaded 57 videos as far as the criminal procedure code is concerned, 62 videos as far as the Indian penal code is concerned, and requested students or those who used to watch my video at the end that by all means you are at liberty to ask me, and if there are such a number of questions or such a number of difficulties or the queries for which it is necessary for me to have one more video, I don't mind, because being a teacher I always like to teach, and that is my passion which will remain forever. With this, now we start with part 22 as far as this series of lectures is concerned. We dealt with section 6, then we dealt with right from section 123 up to 131A. During the course of time, I had also drawn your attention to some of the sections like section 64, section 84, section 89, where we had dealt with, because when I say we dealt with section 6, the next part, that is half part of section 6, for the purpose of understanding the definition of the check. And then now this is the time for me to draw your attention before we proceed to the last chapter as far as the Negotiable Instrument Act is concerned, to draw your attention to section 31 of the act with which we have already dealt. And section 31 of the act deals with what? Liability of drawee of check. And it says, the drawee of a check having sufficient funds. And who is drawee of a check? Check is a bill of exchange drawn on a specified banker, not expressed to be payable otherwise than on demand. And so now, the drawee of a check having sufficient funds of the drawer in his hands properly applicable to the payment of such a check must pay the check when duly required to do so, and in default of such payment must compensate the drawer for any loss or damage caused by such a default. So when the check is dishonored by the banker, namely the drawee banker, the remedy, which is the person who has presented the check to the banker, has got no remedy against the banker, for the simple reason that there is no privity of contract between him and the banker. But if the check is dishonored, and if it is found out that banker was negligent or he was not justified in refusing payment with respect to the check, naturally, under those circumstances, the person, for example, the drawer, because there is a privity of contract between drawer and the drawee banker, that when he is having sufficient funds and when the check is drawn by the drawer and it is presented to the banker, it must be honored, that it must be paid by the banker. So if it is dishonored, the remedy that is available to the drawer against the banker made very clear. But what about liability of the drawee bank? And when the drawee bank is justified in refusing payment with respect to the check, and for that this is the time for you to take into consideration various different situations in which, as it has been rightly pointed out that in the following circumstances, the banker is justified in refusing payment of checks. And then when we start discussing which are the various ways in which a banker is justified in refusing payment with respect to the check, this is a time for me to draw your attention first of all to first situation, namely where the check is post dated. Check is always payable on demand, and hence when the check that is presented to the banker is what is known as post-dated check. As at the time of having a discussion regarding the definition of the check, I made it very clear. Post-dated check, leaf is that of the check, but it cannot be a check because the check is always payable on demand, and when it becomes payable, that check becomes payable only on that particular date which appears on the check. So in case of post-dated check, when it is presented to the banker is justified in refusing payment with respect to the check, and no remedy is available to the drawer against the banker. We are talking about liability of the banker, namely liability of the drawee banker, and hence here the banker is not at all liable. If the case doesn't fall under any one of the categories with which we are dealing at present, then only the banker is liable, otherwise not. Secondly, it says where a check is outdated. Now, though we say that check is always payable on demand, naturally, as per the banking practice and the rules laid down by the Reserve Bank of India, the check used to remain into circulation for a period of 6 months. And after 6 months, that check was known as a stale check or outdated check. There is no such provision in the Negotiable Instrument Act. But now, this from 1st of April 2012, this period of it cannot remain into circulation for a period of 6 months, but it can remain into circulation for a period of 3 months only. And to make it very clear, if I may be permitted to read the circular by the Reserve Bank of India, it says, in the exercise of the powers conferred by Section 35A of the Banking Regulation Act 1949, the Reserve Bank hereby directs that with effect from April 1st, 2012, banks should not make payment of checks, draft, pay orders, bankers checks bearing that date or any subsequent date if they are presented beyond the period of 3 months from the date of such instrument. So now, as per the banking, this is the time to understand Negotiable Instrument Act. It is also necessary for you to refer to some of the provisions as far as the Banking Regulation Act and the Reserve Bank of India Banking Regulation Act of 1949 and the Reserve Bank of India Act of 1934. So where the check is outdated, you present a check to the banker after the period of 6 months, not 6 months now, I'm sorry, it is 3 months now from 1st of April 2012, the banker is justified in refusing payment with respect to the check. 3. When the funds are insufficient, needs no explanation. When you draw a check and the amount the drawer has no balance as far as his account is concerned, that is where the funds are insufficient, banker is justified in refusing payment with respect to the check. When the customer countermands payment. So banker, there is a relationship, contractual relationship between the banker and the customer. The customer had issued a check and now the customer gives direction to the banker to stop payment with respect to the check, and the banker is bound by it. So the banker will refuse payment, he will dishonor the check, and then the banker is justified as far as the payment, justified in refusing the payment of the check is concerned, when customer countermands the payment. Now, when the check is what is known as mutilated, it's a one leaf, but now when it has turned into many parts and it is mutilated and presented to the banker, banker is supposed to carry out payment with respect to the check which is not mutilated. If it is, the banker is justified in refusing payment with respect to the check. Next ground, where the check is of doubtful validity. In other words, when the banker reads the check and as banker has got doubt regarding the validity of the check, naturally the banker is justified in refusing payment with respect to the check. Where customer's signature does not agree. Now there are some points to which I shall draw your attention at the time of discussing section 138, last chapter, as far as the Negotiable Instrument Act is concerned. But then it says where customer's signature does not agree. Banker is justified in refusing payment if the signature that appears on the check does not agree with the specimen signature of the customer. And then there are some grounds where it's not only banker is justified, but banker is also bound to refuse payment. One, where the customer has countermanded payment, banker is bound by the direction, by the contracts, that he must, if there is an order issued by the customer to stop payment, banker is bound by law to stop payment with respect to the check. Where a customer has died. So when the customer has died and banker has notice of it, that notice of his death, the banker is bound by law to stop, not to refuse payment with respect to the check. Where a customer has become insolvent. Now law relating to insolvency can be read by you, no doubt about it, but when he becomes insolvent, this is a time where the banker is justified in refusing payment with respect to the check. Where a customer has become a person of unsound mind. In that case, when he becomes a person of unsound mind, banker is justified in refusing payment with respect to the check. And lastly, where garnishee order has been issued. So when who is garnishee? Garnishee is judgment debtor's debtor. So this is a direction, this is the order that is passed by the court of law to as far as to stop the functioning as far as the account of drawer is concerned, namely not to carry out payment. So under such circumstances, so his drawee banker is garnishee, and if it happens that he receives an order from the court of law not to carry out payment, and then in that case the banker is justified. If at all, as a student of law, if you want to know rest of the details as far as garnishee order is concerned, you can refer to Order 21, rules right from 46 capital A to 46 capital I as far as the Civil Procedure Code is concerned. I again repeat, this is the manner in which you can study law in order to have what is known as holistic approach. So you go on, whenever you come across some point and then you start reading that point, it becomes very easy for you to understand the provisions of the law. With this now, we start with the last chapter, that was an amendment as I had already told you in the past, and we start discussing right from section 138 up to section 147. Now, in the past, prior to introduction of this chapter, if there was a refusal on the part of the banker to carry out payment with respect to the check, the remedy that was available to the person was not against the banker, but the remedy was available to the drawer. Yes. Now, at that time, the remedy that was available to the holder against the drawer was civil remedy to recover the amount for which the check was issued. And at the most, if he could prove in a court of law that drawer had issued the check, and at the time of issuing the check his intention was to deceive, then he could have proceeded as far as criminal law is concerned for the offense of cheating. So in case of cheating, state of the mind of the drawer which is required to be proved must be, the act must be done fraudulently. And what is fraudulently? There must be deception which must result into causing of an injury. But then legislature thought, instead of that, though we say that negotiable instrument, it deals with civil wrongs, why not to have a chapter which deals with criminal liability if the check is dishonored? And as per this chapter, right from section 138, this is the chapter 27, dealing with what? Chapter 17 dealing with what? Chapter 17 dealing with penalties in case of dishonor of certain checks for insufficiency of funds in the accounts. And section 138, dishonor of check for insufficiency etc. of funds in the account. And it says, where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out of that account for the discharge in whole or in part of any debt or other liability is returned by bank unpaid, either because of the amount of the money standing to his credit of that account is insufficient to honor the check, or that if it exceeds the amount arranged to be paid from the account by an agreement made with the bank, such person shall be deemed to have committed an offense and shall, without prejudice to any other provision of this act, be punished with imprisonment for a term which may be extended to 2 years, or with fine which may extend to twice the amount of the check, or with both. So this deals with criminal liability. So drawer can be convicted by the court of law. Drawer can be convicted for the court of law. And what is the punishment that can be inflicted by the court of law? A term, he can be asked to undergo imprisonment for a term which may extend to 2 years, or with fine which may extend to twice the amount of the check. So this is the punishment that can be inflicted by the court of law. Accordingly, legislature thought that there were such many cases where the checks were issued and they were dishonored. So now drawer, before he issues a check, should think over. He should be very serious, and this is to certain extent in order to nip in the bud. Prevention is better than cure. So this is a sort of a measure where a drawer may be liable if he has issued a check and if that is dishonored by the banker. The only point to which I want to draw your attention, the section deals with only insufficiency of the funds. But then if you go through latest case law, I have not referred to the case law while dealing with the provisions of the Negotiable Instrument Act, because you are watching my videos on YouTube. And then in this year 2013, well, by all means it is possible for you, if you, all decisions, namely the decisions which are given by the Supreme Court, the decisions which are given by the High Court are easily available online on the very day. So now if you go to the month of November, and find out the decision that was given by the Supreme Court. A Supreme Court has laid down a law that even though the check is dishonored on the ground that the signature of the signature of the drawer on the check does not agree with the specimen signature, that will constitute liability as far as section 138 is concerned. Or when the check is presented and by that time the account is closed, that will also. So you will, as you go through the case law, when you want to work out the details, you will come to know. But this is when there is refusal on the part of the banker, when the check is dishonored by the banker, not only for this ground, for any other ground also, as per the decision given by the Supreme Court, that constitutes liability subject to. It's not only once the check is dishonored, they will start that will start criminal liability as far as the drawer is concerned, because you have to read this section along with proviso very carefully. And what is proviso to the section? It says provided that nothing contained in this section shall apply unless, very important, the check has been presented to the bank within a period of 6 months from the date on which it is drawn, or within the period of its validity, whichever is earlier. Now, it's not, mind well, as per the circular from the Reserve Bank of India that I had just read out. Now, it's not 6 months but 3 months, or within a period of its validity. If the validity expires earlier, then in that case it is required to be full. So the first thing, the check has been presented to the bank. Check is required to be presented to the banker as far as small a, when we start reading proviso is concerned, then only the person is liable. 2. The payee or the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount of money by giving notice in writing to the drawer of the check within 30 days of the receipt of information by him from the bank regarding the return of the check as unpaid. So once the payee or the holder receives intimation from the banker that the check is dishonored by the banker within a period of 30 days from the receipt of information by him from the bank regarding the return of the check, it is must for him. Then what he should do? He should make a demand for the payment of the said amount of money by giving notice in writing, or notice is required to be given by the payee or the holder to whom? To the drawer, of demanding the payment. And then it must be in writing too, as far as clause small b when we read proviso is concerned. And lastly, the drawer of such check. So drawer, the notice is served upon the drawer, that is also in writing, demanding payment. But then the drawer of such check fails to make the payment of the said amount of money to the payee, or as the case may be, to the holder in due course of such check within 15 days on the receipt of the said notice. So if the amount is paid within a period of 15 days when he has received notice, the notice is required to be served within a period of 30 days from when the person, namely the payee or the holder, receives intimation from the bank that the check has been dishonored. He must demand payment from the bank. And then if it is not, payment is not carried out, the drawer fails to make the payment, drawer, that constitutes liability subject to some other part, some other conditions which are required to be fulfilled, with which we will proceed. But this is as far as liability, criminal liability, as far as section 138 is concerned. The explanation to the section says, for the purpose of this section, debt or other liability means a legally enforceable debt or other liability. So when the check is issued, what was the reason that the check was issued? And that is made very clear as far as this explanation to this section 138 is concerned. With this now, section 139, and what is that? Section 139 says presumption in favor of holder, and it says it shall be presumed unless the contrary is proved. In other words, court will take it for granted unless the contrary is proved that the holder of a check received the check of the nature referred to in section 138 for the discharge in whole or in part of any date or the other liability. So the holder had received the check for the discharge in whole or in part of any date or other liability. That is a presumption unless the contrary is proved as far as section 139 is concerned. With this, section 140, defense which may not be allowed to any prosecution under section 138. So when the drawer is prosecuted as far as section 138 of the Negotiable Instrument Act is concerned, section 140 says, it shall not be a defense in a prosecution for an offence under section 138 that the drawer had no reason to believe that when he issued the check that the check may be dishonored on presentment for the reasons stated in that section. So there cannot be, this defense cannot be raised by in case of criminal liability, there are many defenses which can be raised. The one defense, if you remember, is the defense that your case falls under one of the exceptions right from section 76 up to 106 of the Indian Penal Code, dealing with general exceptions. Yes, that is also a defense. The other defense, if you remember, is here it is not applicable, but by way of information, defense of alibi. That is, I was not present at the scene of the offense. Now, section 140 says, can this be a defense which can be raised by the drawer? And what is that? Drawers, that the drawer had no reason to believe. He cannot say that, well, I had no reason to believe when he issued the check that the check may be dishonored. I had no reason to believe that the check may be dishonored on presentment for the reasons. So it will be dishonored for reasons stated in that particular as per the section. No, he cannot raise this particular defense. That is not at all defense, that is not admissible. That is defense that cannot be raised. That defense that is not allowed as far as section 140 is concerned. With this now, section 141 deals with offences by companies. It says if the person committing an offence under section 138 is a company, every person who at the time the offence was committed was in charge of and was responsible to the company for the conduct of the business of the company as well as the company shall be deemed to be guilty of the offence and shall be liable to be proceeded against and punished accordingly. So when the offence is committed by company, a company, as you will learn the law, you will come to know, is a legal person. Partnership is not a legal person. It has got no distinct legal personality existence, but a company has. And hence, if the offence is committed by the company who is liable, is made very clear as far as section 141 is concerned. It says if the person committing an offence under section 138 is a company, every person who at the time of the offence was committed was in charge of and was responsible to the company for the conduct of the business of the company as well as company shall be deemed to be guilty of the offence and shall be liable to be proceeded against and punished accordingly, provided that nothing contained in this subsection shall render any person liable to punishment if he proves that the offence was committed without his knowledge or that he had exercised all due diligence to prevent the commission of such offence. Provided further that where a person is nominated as a director of a company by virtue of his holding any office or employment in the central government or state government or financial corporation owned or controlled by the central government or the state government as the case may be, he shall not be liable for prosecution under this chapter. And subclause 2 says, notwithstanding anything contained in subsection 1, where any offence under this act has been committed by a company, and it is proved that the offence has been committed with the consent or connivance of, or is attributable to any neglect on the part of any director, manager, secretary, or other officer of the company, such director, manager, secretary, or other officer shall also be deemed to be guilty of that offence and shall be liable to be proceeded against and punished accordingly. Explanation: for the purpose of this section, company means any body corporate and includes a firm or other association of individuals, and director in relation to a firm means a partner in the firm. With this now, what is the manner in which cognizance of an offence can be taken? And that is made very clear as far as section 1. Offence has taken place as per section 138. 142 tells us that what is the manner in which cognizance of the offence may be taken by the court of law. And it says, notwithstanding anything contained in Code of Criminal Procedure of 1973, no court, now mind well, no court shall take cognizance of any offence punishable under section 138 except upon a complaint in writing made by the payee, or as the case may be, the holder in due course of the check. So there must be a complaint that must be in writing on the part of the payee, or as the case may be, the holder in due course. Then only the cognizance of an offence can be taken. In order to know details as far as taking cognizance of an offence is concerned, this is the time for me to draw your attention. You can read right from section 190 up to 199 of the Criminal Procedure Code, along with the limitation for taking cognizance of an offence laid down right from section 467 onwards up to section 473 of the Criminal Procedure Code. But here the small a says, no court shall take cognizance of any offence punishable under section 138 except, so cognizance may be taken upon a complaint in writing made by payee, or as the case may be, the holder in due course of the check. So small b, such complaint is made within 1 month of the date on which the cause of action arises under clause C of proviso to section 138. So now made very clear, such complaint should be made. I mean, this is the time limit that has been laid down. It's not that you can go to the court of law as per your convenience. No. Such complaint is made within 1 month of the date on which the cause of action arises. So one check is presented. The check is dishonored. The person who had presented may be payee on holder in due course receives intimation from the banker regarding dishonor of the check. He has given notice of demand, and in spite of the fact that he has served a drawer with notice for demand as far as the payment is concerned, there is failure on the part of the drawer. Then that is the time, I mean, the days are mentioned. I mean, as you refer to section subclause 3, if the drawer of such check fails to make the payment of the same amount of money to the payee as the case may be, to the holder in due course of the check within 15 days. So as soon as this period expires, the cause of action arises, and there starts the liability, because when a drawer is liable as far as section 138 is concerned, for that we have dealt with section 138 in detail. So this is, such complaint is made within 1 month. Complaint must be made within 1 month of the date on which the cause of action arises under section C of proviso to section 138. provided that the cognizance of a complaint may be taken by the court after the prescribed period if the complainant satisfies the court that he had sufficient cause for not making a complaint within such period. So that is it is the cognizance may be taken after expiry of this period, namely the period complaint must be made within 1 month. So there can be cognizance may be taken when, provided that the cognizance of a complaint may be taken by the court after prescribed period if the complainant satisfies the court that he had sufficient, if he can prove in a court of law that he had sufficient cause for not making a complaint within such period. And clause small c says no court, which court can take cognizance of an offence? As far as section 138 is concerned, it says no court inferior to that of a metropolitan magistrate or a judicial magistrate of first class shall try any offence punishable under section 138. So this is cognizance can be taken only by metropolitan magistrate or a judicial magistrate first class as far as section 142 is concerned. Now what is the manner in which the trial will take place? And the procedure regarding trial is dealt by the provisions of the Criminal Procedure Code. There are various trials: trial before a court of session, trial of a warrant case by magistrate, trial of a summons case by magistrate, and summary trial. Now section 143 says power of court to try cases summarily, and it says notwithstanding anything contained in the Code of Criminal Procedure 1973, all offences under this chapter shall be tried by a judicial magistrate of the first class or by a metropolitan magistrate, and the provisions of section 262 to section 265, both inclusive of the said code, shall, as far as may be, applied to such trials. So the guidelines are given that the whatever procedure is laid down as far as summary trial is concerned, as far as the Criminal Procedure Code is concerned, is also made applicable as far as the offence as per section 138 of the Negotiable Instrument Act is concerned, provided that in case of any conviction in a summary trial under this section, it shall be lawful for the magistrate to pass a sentence of imprisonment for a term not exceeding 1 year and an amount of fine exceeding 5,000 rupees, provided further that when at the commencement of or in the course of a summary trial under this section, it appears to the magistrate that the nature of the case is such that a sentence of imprisonment for a term exceeding 1 year may have to be passed, or that it is for any other reason undesirable to try the case summarily, the magistrate shall, after hearing the parties, record an order to that effect, and thereafter recall any witness who may have been examined and proceed to hear or rehear the case in the manner provided by the said code. So there is a provision in the Criminal Procedure Code that a court has got power, and hence the court may start dealing with the case as if it is a trial of a summons case accordingly by following the procedure. So that is it. Subclause 2 says the trial of a case under this section shall, so far as practicable, consistently with the interest of justice, be continued from day to day until its conclusion, unless the court finds the adjournment of the trial beyond the following day to be necessary for reasons to be recorded in writing. Now, if you read clause 3, it says every trial under this section shall be conducted as expeditiously as possible, and an endeavour shall be made to conclude the trial within 6 months from the date of filing of the complaint. Justice delayed is justice denied. With this in view, the provisions you come across when we talk about trial, we come across 2 subclauses. Subclause 2, which says the trial of the case under this section shall, so far as practicable, consistently with the interest of justice, be continued from day to day until its conclusion, unless the court finds the adjournment of the trial beyond the following day to be necessary for reasons to be recorded in writing. And subclause 3 says, every trial under this section shall be conducted as expeditiously as possible, and an endeavour shall be made to conclude the trial within 6 months from the date of filing of complaint. Section 44, 144 deals with mode of service of summons, and it says, notwithstanding anything contained in the Code of Criminal Procedure 1973, and for the purposes of this chapter, a magistrate issuing a summons to an accused or a witness may direct a copy of the summons to be served at a place where such accused or witness ordinarily resides, or carries on business or personally works for gain, by speed post or by such courier service as are approved by the Court of Session. So that can be, as far as the service of summons is concerned, we made clear as far as subclause 1 is concerned of section 144. Subclause 2 says, where an acknowledgement purporting to be signed by the accused or the witness, or an endorsement purported to be made by any person authorized by the postal department or courier services, that the accused or the witness refused to take delivery of the summons has been received, the court issuing the summons may declare that the summons has been duly served. With this now, this is the mode of service of summons. There are various ways in which it is possible for the court of law to compel appearance of an accused person or compel witnesses in a court of law, maybe, for which you can refer to right from section 61 up to section 90 of the Criminal Procedure Code, where you will come across, the provisions. Now, this is, and then this is how the manner, mode of service of summons is dealt as far as section 144 is concerned, as far as the offence which is committed as defined by section 138 of the Negotiable Instrument Act. 145, evidence on affidavit, and it says, notwithstanding anything contained in the Code of Criminal Procedure 1973, the evidence of a complainant may be given by him on affidavit and may, subject to all just exceptions, be read in evidence in any inquiry, trial, or other proceedings under the said code. So the manner in which evidence can be given on an affidavit, as for the evidence of the complainant may be given by him on affidavit as far as section 145 is concerned. The subclause 2 says, the court may, if it thinks fit, and shall, on the operation of the prosecution or the accused, application of the prosecution or the accused, summon and examine any person giving evidence on affidavit so as to the facts contained therein. So there is a provision whereby if there is an application of the prosecution or the accused, then summon and examine any person. The court may summon and examine any person giving evidence on affidavit. Otherwise, the court can admit the evidence which is given on affidavit as far as section 145 is concerned. Now, let me tell you at this juncture that unless you know the procedure as far as trial is concerned, and procedure regarding trial can be understood by you subject to one condition, that you know the provisions of the Criminal Procedure Code. What is trial? It is a process whereby evidence is recorded in order to prove the guilt of the accused person beyond reasonable doubt, with which you shall be dealing, or with which you can understand, subject to one condition, that you have mastery as far as the Criminal Procedure Code is concerned. Now, section 146, bank slip prima facie evidence of certain facts, and it says, the court shall, in respect of every proceedings under this chapter, on production of bank slip or memo, having thereon the official mark denoting that the check has been dishonored, presume the fact of dishonor of such check unless and until such fact is disproved. So now this is, what the court shall does not include shall not. It is mandatory. Court shall. In respect of every proceedings under this chapter. So when the proceedings are as per this chapter, right from section 138 onwards, when there is production of bank slip or memo, having thereon the official mark denoting that the check has been dishonored. Check has been dishonored. The court will presume the fact of dishonor, so it cannot be challenged. It will be taken for granted by the court of law that the check was dishonored unless and until such fact is disproved. So it is the burden is on the opposite party to prove and then that well it is not so, it was not dishonored. Otherwise, I mean, unless and until such fact is disproved, otherwise court will take it for granted. These are the term proved, not proved, disproved, with which I mean you will come across as you understand the provisions as far as the Indian Evidence Act is concerned. With this we come to last section, namely section 147, which says offences to be compoundable, and it says notwithstanding anything contained in the Code of Criminal Procedure Code of 1973, every offence punishable under this act shall be compoundable. So this offence as defined by section 138 is compoundable offence. And then in order to know details, there are, I mean, when you talk about compoundable offences, we can take into consideration compoundable with the permission of the court, and non-compoundable offences. What is the effect of compoundable offences? If you refresh, if you have reference to section 320 of the Criminal Procedure Code, compounding of an offence, who can compound the offence? When he can compound the offence, you learn section 320, you will come to know the effect of compounding of an offence amounts to an acquittal. And then once the person is acquitted, there cannot be a trial because of section 300 of the Criminal Procedure Code, which deals with autrefois acquit or autrefois convict. So these offense, once the offense is compounded, compoundable offense means that as in case of Civil Procedure Code, there is what is known as compromise decree. And once there is a compromise decree, there cannot be again suit because that is barred as far as res judicata is concerned, which is dealt as far as section 11 of the Civil Procedure Code is concerned. Here it is dealt as far as autrefois acquit or autrefois convict is dealt as far as the section 300 of the Criminal Procedure Code is concerned. So that is, these offences are compoundable before final pronouncement of the judgment. Yes, as per section. So to understand section 147, the time for you to refer to also section 320 of the Criminal Procedure Code, which will serve purpose. With this now, this is the end as far as the series of lecture on the Negotiable Instrument Act is concerned. As I have told you, I have tried my best to simplify the subject as and when it is possible, or the manner in which it is possible. But this being, I had made one thing very clear right in the beginning. This is a subject which is very negotiable. Instrument Act is very difficult to negotiate. Hence, in spite of sincere efforts on my part, if at all you have any problem, don't hesitate to mail me, and my email ID is prof.deshmukh@gmail.com. And then if there are many difficulties, if there is one or two if there is only one difficulty or hardly few difficulties, I can immediately, once I receive the same, I will talk to him. Otherwise, we can have such a video for the purpose of taking into consideration the response that I get from all of you. With this now, Yet, there is request on the part of many to upload more videos as far as other subjects are concerned. But at this stage, I don't want to commit. I have already uploaded three entire subjects, namely the Criminal Procedure Code of 1973, the Indian Penal Code of 1860, and the Negotiable Instrument Act as far as 1881 is concerned. With this, I take this opportunity to wish you happy, healthy, and prosperous 2013. And last but not the least, let me take this opportunity to wish you all the best as far as your career is concerned. Thank you very much.